When family planning fails, the implant that was never there. Before we begin this video is for public education only. We are discussing a real issue, a real court decision that has already been determined. The purpose is not to shame, attack, or defame any patient, healthcare worker, hospital, or institution. This episode is meant to help patients, families, healthcare workers, and the public understand the important lessons about family planning, informed consent, medical documentation, patient rights, and professional responsibility. This is not legal advice, not medical advice. For personal medical or legal concern, please consult a qualified professional. Imagine this. A woman and her husband sit together and make a serious family decision. They already have 2 children. They look at their income, their responsibilities, their future, and the kind of life they want to give their family. After thinking carefully, they decide, for now, 2 children are enough. So the woman goes to the hospital to seek family planning advice. She wants a reliable method. She wants something that will give her peace of mind for some years. She trusts her healthcare system. She trusts that the procedure will be done properly. She is advised about a contraceptive implant called Implant. She's told it can prevent pregnancy for about 3 years. She agrees. She believes the implant has been inserted into her upper arm. She goes home confident. But about 1 year later, something unexpected happens. She becomes pregnant. And then comes the most shocking part. Test later shows that there was no implant in her body. Not a failed implant, not an expired implant, not an implant that moved. According to the court's record, there was no implant inserted at all. This is the story of the case between a hospital in the Republic versus AAA. It was decided by the Court of Appeal of Kenya in 2019. In simple terms, there was a medical negligence case involving family planning services. The patient identified in the court record as AAA had gone to the hospital for contraception. The hospital was the appellant in the appeal case. The court record states, around 4th July 2011, the woman sought advice on appropriate contraceptive method because she and her husband had decided that 2 children were enough for them. She was advised to use Implant, which she was assured would prevent contraception for 3 years. She agreed to the procedure. According to the case, she believed that the implant had been inserted in the inner part of her upper left under local anesthesia. She was then assured that she could resume marital relations without using any other contraceptive. For her, the matter was settled. She had made a family planning decision. She had gone to a health facility. She had followed professional advice. She believed she was protected. And on 10th August 2012, within 3-year period, she believed she was protected. The woman's suspicions was confirmed. She was pregnant. For many families, pregnancy can be a joyful event. But for this family, the pregnancy was not planned. It came after a deliberate decision to prevent pregnancy. It came after hospital visits. It came after counseling. It came after what she believed was a contraceptive implant procedure. The emotional weight of that moment is difficult to ignore. Question must have filled her mind. How did this happen? Did the implant fail? Was it inserted wrongly? Was there a rare medical failure? But the answer was even more disturbing. The court record states that the test confirmed there was no implant inserted in her body, contrary to what she had been made to believe. That discovery changed the case completely. This was no longer simply a story of failed contraception. It became a story about trust. Trust in counseling, trust in documentation, trust in a medical procedure, trust in the words of a healthcare provider. In time, the woman delivered a healthy baby girl on 26th March 2013. And this is where the story begins legally and emotionally complex, because the baby was healthy. The child herself was not the problem. The legal issue was not whether a child has value. Every child has value. The question before the court was different. The question was, if a hospital negligently caused a woman to become pregnant after family planning care, can the hospital be ordered to pay the cost of raising that child until adulthood? The question is difficult because it sits at the center of medicine, law, family life, ethics, money, and human dignity. Before the child was born on 7th January 2013, the woman filed a medical negligence claim in the High Court. She sought compensation for several things: pain and suffering, psychological distress, mental anguish, antenatal care and delivery costs, and the cost of caring for and bringing up the child until the age of 18. After the baby was born, she amended her claim to include the fact that the child has been born and that the baby was not planned for, and the birth had disrupted the family socioeconomic plans. This is important. The case was not saying that the child was worthless. It was saying that the pregnancy had come after a medical service that was meant to prevent pregnancy. And because of that, the family argued that they had suffered financial and emotional consequences. What happened at the High Court? At the High Court, the hospital entered appearance but did not file a defense. Because of this, the default judgment was entered. The case then proceeded to formal proof, where the partner, patient, husband, and the doctor gave evidence. The doctor evidence confirmed that no implant had ever been implanted in the woman's body. The High Court awarded her Kenyan shillings 500,000 for pain, suffering, and loss of amenities, and 4,320,000 for the cost of caring for and bringing up the child from birth to 18 years. The High Court also made an important statement. Family planning is widely acceptable in Kenya, and hospitals and doctors who offer it owe patients a duty to perform those services according to the expected professional standard. That statement was powerful because it reminds healthcare workers that family planning is not a casual service. It's a serious medical intervention that affects the future of a patient and a family. The hospital appealed. But at the Court of Appeal, the hospital did not challenge the finding on liability. The hospital also abandoned the challenge to 500,000 award for pain, suffering, and loss of amenities. So the main issue became this: was the High Court right to award 4,320,000 for the cost of raising a healthy baby but unplanned child until adulthood? This became the heart of the case. The Court of Appeal had to weigh two difficult sides. On one side, the woman had made a clear reproductive decision. She had sought medical help to avoid another pregnancy. If the hospital negligence caused her to carry an unplanned pregnancy, should she not be compensated for the consequences? On the other side, how should the law treat the birth of a healthy child? Can the cost of raising a child be treated as a legal loss? Would that appear to suggest that the child's life is a damage? On the other side, how should the law treat the birth of a healthy child? And the cost of raising a child be treated as a legal loss? Would that appear to suggest that the child's life is a damage? These are not easy questions. And that's why this case is so important for public education. The Court of Appeal recognized that the issue was complex. It was not just a medical question. It was not also a legal question, an ethical question, a social question, a family question. The court reviewed the decision from other countries where judges had taken different positions on whether the cost of raising a child born after failed contraception should be recoverable. Some courts had allowed such compensation. Others had rejected it. The Kenyan Court of Appeal observed that the issue placed court in a difficult position because, on one hand, 9 child-raising costs may undercompensate the parent for the wrong suffered. But on the other hand, awarding child-raising costs may appear to treat the child's existence as a continuing source of loss. That is why language matters. When discussing this case, we might not say the child was a damage. That would be wrong and insensitive. Instead, we should say the court considered whether the financial cost of raising a healthy and unplanned child could be recovered as damages after negligent family planning care. That is a proper way to frame it. The final decision. In the end, the Court of Appeal reached a split outcome. First, the court accepted that the award of 500,000 Kenyan shillings for pain and suffering was proper. In fact, the Court of Appeal said that the award for pain and suffering was properly awarded, especially because the conduct of misleading the respondent that she had been implanted with an implant on road when she had not. But the court disagreed with an award of 4.3 million for the cost of raising the child. The Court of Appeal set aside that part of the award. The court reasoned that awarding the full cost of raising a normal and healthy child was not justified. It also considered Article 53 of the Constitution, which recognizes the child's right to parental care and protection, including equal responsibility of the mother and father. So the final result was the woman kept the award for pain and suffering, but the award for child upbringing cost was removed. Let us pause and ask, what should healthcare workers learn from this case? The first lesson is that family planning is not a small procedure. A contraceptive implant may be small in size, but the decision behind it is very big. It affects the woman's body, it affects her marriage, it affects finances, it affects career planning, it affects the number and spacing of children, it affects the future of the family. So every step must be taken seriously. The second lesson is this: do not assume the procedure is complete unless it is confirmed. For an implant, the provider should confirm the implant is actually inserted. The patient should be educated on what to expect. The site should be documented. The patient should be given proper follow-up information. Where applicable, the patient should receive a card showing the method, insertion date, expected day of removal, and warning signs. In medical legal cases, the court does not only ask what you intended to do. The court asks, what did you actually do? What did you document? What did you tell the patient? What evidence supports your version? The third lesson is documentation. In healthcare, documentation is not just proper paper. Documentation protects the patient, healthcare worker, institution, continuity of care. A proper family planning record should clearly show the method chosen, the counseling given, the risk discussed, the consent obtained, the date of insertion, the site of insertion, the batch or lot number where applicable, the name and designation of the provider, the follow-up plan and the follow-up plan, and any instruction given to the patient. Because when a case reaches the court, memory is weak, but records speak. The fourth lesson is communication. Patient may not remember medical terminology. They may not understand the failure rate. They may not know when a contraceptive method became effective. They may not know what to do if they cannot fill the implant. They may not know when to return. So counseling must be simple. Use language the patient understands. Ask patient to repeat key instructions. Give written information where possible. And remember, consent is not just a signature. Consent is understanding. This case is also important for the patient and the public. When you receive family planning care, do not be afraid to ask questions. Ask, what method am I receiving? How does it work? When does it start working? How long will it protect me? What side effects should I expect? What warning signs should make me return to the hospital? Can I fill the implant? Should it be removed? Do I need to back up contraception for some days? Can I get a card with written records? These questions are not disrespectful. They are part of safe healthcare. A good healthcare worker welcomes questions. Here are the questions I'd want to discuss respectively in the comment section. When a patient seeks family planning and a medical mistakes lead to pregnancy, what kind of compensation is fair? Should the cost of raising a healthy and unplanned child ever be paid by negligent healthcare provider or hospital? Let us summarize the main lessons from this case. First, family planning is not a minor clinic service. It's a major life decision. Second, healthcare workers must ensure that the procedure is actually done and properly confirmed. Third, documentation is essential. In court, good records can make all the differences. Fourth, patient must be counseled in simple language they understand. And fifth, a healthy child is never to be described as damage. The legal issue is the financial and emotional consequence of negligent care, not the value of the child's life. This case began with a family decision. A woman and her husband decided how many children they wanted. They trusted the hospital to help them follow that decision. But somewhere along the way, according to the court record, that was broken. The court case ended, but the lessons remain alive. In healthcare, every procedure matters. Every counseling session matters. Every consent matters. Every note matters. Every patient explanation matters. Family planning is not just prevent pregnancy. It's about respecting a patient's life plan. It's not about trust. And when trust is broken, the courtroom may become the place for a healthcare decision are examined word by word, note by note, and action by action. My name is Wilfred, the healthcare educator. On this channel, we use medical legal cases to educate healthcare workers, patients, families, and public. The aim is not to blame. The aim is learning. Because when we understand what went wrong, we can build safer healthcare system. If this story taught you something, subscribe to the channel. Share the video with healthcare workers or patients and leave your thoughts in the comments. In the next episode, we will look at another real case where medicine met the law.